Good morning, Attorney Famiglietti. I just wanted to note that inmate Delgado, number 436653, will be heard at 10:30 a.m. Hearings will be starting at 9:15 a.m.
Good morning.
Good morning. Did you hear my message?
Yeah, he's not going to be, he's at Osborn.
Yeah, I'm hearing him at 10:30 with the Osborn block.
Okay, do you know anywhere, we'll just see who's there first? Are you going to go right down the list or?
No, I want to see, I don't know who's going to be there. Usually she's pretty good about getting them down.
Yeah.
If they're all there, I'll probably do Delgado first,
Okay,
and then just go down the line.
okay.
So-
Do you know if Osborn is aware that Delgado has a hearing today?
Yeah, I spoke to them this morning. Yep,
Awesome, you rock. Okay, thanks so much.
no problem.
See you then.
Yep. Good morning.
Hi, good morning.
Morning. I'm gonna start with Mr. Rivera. Is he there?
No, no one is here as yet.
Okay, I'll see. Well, actually, just go down the line then. Rivera, Duran, and Link.
Okay, so Rivera and Link. Okay, as soon as he comes in, I'll have him seated.
Thank you.
You're welcome. Got Rivera, right? Link. We're inside the seat and share and show here. So, okay.
Good morning,
Morning.
Mr. Rivera.
Yes, ma'am.
Good morning. We're gonna get started with your preliminary hearing in a minute, okay?
All right.
You reach parole officer Tyson with the you have reached parole officer Tyson with
I'll be right with you, sir.
No problem.
Thanks. Okay, so I'm just gonna get started. Good morning, I'm P.O. Meisinger, a hearing examiner for the Board of Pardons and Paroles. This is a preliminary hearing concerning Rivera Waldemar, number 249194. Today is December 10th, 2024. This hearing is being conducted via video at the BOPP Central Office in Carl Robinson Correctional Institution. This is a public hearing. Public access to this hearing is available via video live stream. Can you please state your full name and DOC inmate number for the record, sir?
I'm Waldemar Rivera, 249194.
Thank you. And you have a parole officer present. Can you please identify yourself for the record?
Hi, this is Parole Officer Stacey Patnato.
This is a preliminary hearing, which is the purpose under Connecticut law. It's to determine if there is probable cause to believe you commit an act that violated the conditions of your parole, determine if the act is sufficiently serious to warrant revocation of your parole, and to determine if you should be held in prison pending further proceedings. The state, not you, has a responsibility to show there's probable cause to believe you violated one or more conditions of your parole. If I do not find probable cause, I'll reinstate your parole, which is release you and place you back on parole supervision. If I find probable cause and determine the act is sufficiently serious to warrant revocation, you may be held in prison pending further proceedings. You should know preliminary hearing is a virtual proceeding. Anything you say at this hearing can be used against you. This hearing is being recorded. So this is the procedure for today. I'm going to read you your rights. Then we're going to review the parole violation charge the state appeal is bringing against you. I will review and identify exhibits filed for the record. The state will then have an opportunity to just issue a probable cause and the severity of the allegations. After the state is finished, you will have the same opportunity. At the conclusion of the hearing, I will inform you my findings, which are based on the available evidence. Do you have any questions about the purpose or procedure?
No.
Okay. You have important rights today, the right to have an attorney present. Do you want to continue without counsel?
Yes.
You have the right to receive the written notice of charges of violation. Did you receive the written notice?
Yes.
You have a right to view the evidence against you, the right to submit evidence in support of your case. At this hearing, you have a right to call and examine voluntary witnesses and cross-examine adverse witnesses. Do you understand these rights and are you ready to move forward?
Yes.
All right, so we'll now review the charge state appeal is bringing against you and the information underlying each charge. So P.O. Patnato, if you please read the charges.
Yes, under obey all laws, obedience to the law. On 11/6/24, you were operating a motor vehicle. You failed the one-leg stand and the walk and turn field sobriety test. It was determined that you were under the influence of alcohol and submitted a chemical breath test sample, which indicated a positive result of 0.1906 BAC. Based on your actions, you were charged with violation of Connecticut General Statute 14-227A, operating a motor vehicle under the influence of alcohol and/or drugs, and 14-301, failure to obey a stop sign. This is a violation of your standard parole condition, obey all laws. And under alcoholic beverage consumption, no consumption of alcoholic beverages. On 11/6/24, you were operating a motor vehicle. You failed the one-leg stand and the walk and turn field sobriety test. It was determined that you were under the influence of alcohol and submitted a chemical breath test sample, which indicated a positive result of 0.1906 BAC. On 11/8/24, you signed a voluntary admission form indicating that you drank alcohol.
Thank you. And the state has filed the following exhibits that are pre-marked for identification purposes as Exhibit A, conditions of special parole, B, decision information summary, C, Bristol police report ending in 5073, D, voluntary admission form 11/8/24, E, judicial branch pending case detail, F, remand actual custody order, G, parole violation report, H is notice of parole violation. Did you receive notice of parole violation report, and those other documents I marked, and did you review them?
Yes.
And do you need to continue this hearing to obtain any additional evidence?
No.
We don't have any witnesses today. So at this time, the state is going to have an opportunity to make a short statement or testify with respect to probable cause and the severity of the allegations. I'm going to swear you in, Mr. Rivera, as well as P.O. Pettinato, so you can both speak today if you would like to. So can you please raise your right hand? You solemnly swear, sincerely affirm, as the case may be, the evidence you shall give in this case shall be the truth, the whole truth, and nothing but the truth, so help you God upon penalty of perjury?
Yes.
So, P.O. Pettinato, would you like to say anything? This would be the one time.
Just quickly, sure. So I just wanted to note that Mr. Rivera has been out in the community for about a year. He was working full-time, overall cooperative. This incident was, an unfortunate incident. However, this arrest, obviously put himself at risk, put the community at risk, and, is a violation of his conditions of parole. So at this time, the PCS is requesting that the board make a finding on all charges and that he does continue to remain incarcerated until, at this time. That's all.
All right, thank you.
You're welcome.
So is now your opportunity to respond to parole violation charge against you. Well, I remember that you may remain silent. Would you like to respond to the charges, sir?
No. I did it.
Okay. All right, so what I'm going to do next then is I'm going to announce my findings. So I make a finding of probable cause on charge 1 condition, obey all laws, obedience to the law, based on the evidence and testimony presented in support of the violation, exhibits A, C, and E. And I make a finding of probable cause on charge 2 condition, additional conditions, no alcohol consumption, based on the evidence and testimony presented in support of the violation, which is exhibits A, D, and C. And I do find the acts are serious enough to warrant revocation. I determine you should be detained while you wait for revocation hearing. At the rev hearing, myself or another hearing examiner will determine if you violated the conditions of your parole. If so, the hearing examiner would make recommendations regarding whether your parole should be revoked, what any sanctions should be imposed. So upon disposition of those charges, after you go to court, we bring you back and determine if there's a violation or not. So I'll see you when those charges are taken care of.
All right.
Okay, so you're all set for today, sir.
You guys have a good one.
You too. Thank you, P.O. Pettinato.
All right. Thank you. Have a nice day.
You too.
Okay. Great.
Good morning.
Good morning,
Good morning.
Mr. Duran-Infante.
Yes.
We're here today for your revocation hearing, and I have your attorney here. So we are going to get started, okay?
Okay.
Good morning, I'm P.O. Meisinger, hearing examiner for the Board of Pardons and Paroles revocation hearing concerning Duran-Infante Samuel, number 437440. Today is December 10th, 2024. This hearing is being conducted via video at the BOPP Central Office in the Carl Robinson Correctional Institution. This is a public hearing. Public access to this hearing is available via video live stream. Can you please state for me your full name and DOC inmate number for the record?
I'm Duran, 437440.
You have counsel here today. Can you please identify yourself for the record?
Yes, thank you. Attorney Sonia Jones, Public Defender's Office, Parole Revocation Unit, on behalf of Mr. Duran-Infante.
This is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of fact as to each of the charges against you. The state, not you, has responsibility to prove the allegations by a preponderance of evidence, that is. The better weighted evidence must establish that, more probable than not, the allegation is true. If I do not find that there is a preponderance of evidence to support a violation or conditions of your parole, I will reinstate your parole, which means releasing you, place you back on parole supervision. If I find you have violated one or more conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I'll make a recommendation as to appropriate sanction, and my recommendation be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing would be provided to justify additional confinement. So this is the procedure for today. I'm going to read you your rights. Then we're going to review parole violation charge, state your PO is rained against you. I will review and identify exhibits filed for the record. Counsel will then have an opportunity to present a relevant testimony. After considering all the evidence presented, I'll announce my findings. If I find that you have violated one or more conditions of your parole, counsel will have an opportunity to speak to your background history. Do you have any questions about the purpose or procedure?
No.
Okay, you have important rights today. The right to have an attorney present, and you have counsel here. You have right to receive the written notice of charges of violation. Did you receive the written notice?
Yeah.
You have a right to view the evidence against you, right to submit evidence in support of your case. At this hearing, you have right to call and examine voluntary witnesses and cross-examine diverse witnesses. Do you understand these rights and are you ready to move forward?
Yes.
All right, so we'll now review the charge, state your PO that's written against you, and the information underlying each charge. Charge 1, rebel laws will be into law. You're charging officer reported at 9/22/24 involved in a physical domestic dispute with your significant other in which you struck her in the face, causing visible injuries. You were subsequently arrested by Waterbury Police Department for assault 3rd, criminal mischief 3rd, breach of peace 2nd. Due to this, you are in violation of PCS conditional bail laws will be into law. In the state has filed the following exhibits that for identification purposes are marked as follows. Exhibit A, CT remand to custody. B, CT signed conditions of parole. C, notice of parole violation, parole rights. D, parole violation report. E, state of Connecticut judicial branch documents. F, police reports. And G is arrest warrant. And did you receive notice of parole violation report, and those other documents I marked, and did you review those?
Yeah.
And counsel's filed the following exhibit that is pre-marked for identification purposes as defense exhibit 1. List of parole accomplishments and future plans for parole reinstatement. Do you need to continue this hearing to obtain any additional evidence?
No.
We don't have any witnesses today. I will put on the record, I did receive an addendum from PCS. The addendum reported on 11/5/2024, you were convicted of breach of peace 2nd and received an unconditional discharge with all other charges dismissed. So it's now defense's opportunity if you'd like to speak to any of the evidence at this time.
Thank you. I would just indicate the addendum is stated accurately, and then just by way of a comment to that charge, I would just note that it's my understanding that this was a dual arrest situation and that there is a pending warrant for the alleged victim, and I would call her a co-defendant. And I know that her charge is assault in 2nd degree. However, I was unable to view a copy of that warrant, and that's all I'll place on the record in regards to that charge. Okay. Thank you.
All right, so what I'm going to do next is I'm going to announce my findings. So on that charge 1, I do find you violated conditional bail laws, obedience to law, based on your conviction of breach of peace 2nd and received a sentence of unconditional discharge, as well as exhibits that were provided by the state, which are B, D, F, and G. That includes the fact-finding portion of this hearing. Before I make a recommendation, counsel will have an opportunity to speak to your background and history. This purpose part of the hearing is to help determine what outcome I will recommend. So if you would like to at this time.
Yes, thank you. My client is 26 years of age. He does have one child who's 6 years old. He does have a support system by way of his father, his brother, his uncle, all of whom reside in the Waterbury area. My client was in the community for a little over 5 months, and this is his first violation of his parole. During the time period that he was in the community, he was gainfully employed, working through the Best Temp Agency, and he was placed at a waste management company in Newtown. Also worked at a company in Berlin doing shipping and receiving. He was on a GPS bracelet. He was compliant with the conditions of that bracelet. He was also participating in the 26-week Explorer program at Wheeler Clinic, and he had successfully completed 8 of 26 classes during that time period that he was in the community. Again, this is his first violation of his parole. Upon being re-paroled, he's asking to self-sponsor, and that address is contained within Defense Exhibit 1. As a second alternative option, he's asking to be placed in a halfway house in the Waterbury jurisdiction. He does have employment that he can go to working at his father's store, and that's Duran Market, located on East Main Street in Waterbury. We are asking, based on the court disposition, again, I believe this is a mutual combative situation where, in this situation, my client only pled to a breach of peace in the 2nd degree. I believe the co-defendant has charges that are felony charges. I would be asking that my client be reinstated and re-paroled at the next available date. Thank you.
Thank you. I'll be right with you with my recommendation. All right. So I have reviewed all of the evidence submitted by the state and listened to testimony. We'll put on the record, the defendant has been on parole, which looks like for about 3 months. There is a history of domestic violence as well as this new conviction that is also domestic violence related. So that is somewhat concerning that this keeps happening. And you were involved in domestic violence programming in the community, is that correct?
Yes.
Can I just, I believe he was released to parole supervision on April 25th. Is that not accurate?
I have 6/24 of 24. That was parole. He may have been on community release prior, but he didn't start discretionary parole till 6/24/24.
Okay, but were you in the community as of April 25th?
Yeah.
He could
Yes,
have been
okay,
on community
okay.
release, but I'm counting from time he
Yes.
started parole. It's about
Okay,
3 months. So based on this information, and you are on discretionary parole, so if I do re-parole you or recommend re-parole, that is a on or after date, just like your voted to parole date is. Just so you're aware of that. So I am going to recommend that parole be revoked to be re-paroled for February 3rd of 2024, which is about a 4-month period of confinement as a sanction. Recommend the following parole conditions: behavior management program for domestic violence, no contact with your co-defendants, Royman Valderrama, Booker Jordan, and Trey Murphy, no contact with your victim, MALR, without PO's permission. And I'm going to add a halfway house just in case. I'm going to put your self-sponsored residence to go to, but I'm going to put there just in case something happens in the meantime. My recommendations, which is what this is going to the parole board on December 19th. So the board's going to review this. So the board can let you out sooner, as soon as 12/19, or they can also hold you in longer, or they can revoke all of your parole as well. So it's going to be up to them to make the decision, and you'll be notified in writing from the board about a week after 12/19. And you can speak to your attorney as well regarding the decision by the parole board.
Can I just just correct your re-parole date? I believe you indicated 2/3 of 24, 2/3 of 25.
25,
Yes.
correct. 2025. Thank you.
Thank you. Okay, Mr. Duran-Infante, if you have any questions, please contact my office, okay?
Okay.
Okay.
Great.
Thank
So you're
you.
all set
Good
for
luck.
today.
Have a good day.
Good morning, Mr. Link.
Morning, yes.
Morning. We're here today for your preliminary hearing, which is also, you've been referred to diversion, so I'm sure you're aware of that now
Yes,
that you're
ma'am.
at Robinson. So we're going to get started. Are you all set to start?
Yes.
Good morning. I am P.O. Meisinger, a hearing examiner for the Board of Pardons and Paroles. This is a preliminary hearing concerning link Jason number 243647. Today is December 10th, 2024. This hearing is being conducted via video at the BOPP Central Office in the Carl Robinson Correctional Institution. Can you please state your full name and DOC inmate number for the record, sir?
Jason Link, 243647.
And you have counsel here today. Can you please identify yourself for the record?
Yes, thank you. Attorney Sonia Jones, Public Defender's Office, Parole Revocation Unit, on behalf of Mr. Link.
So this is a preliminary hearing. It's the purposes under Connecticut law. It's to determine if there's probable cause to believe you commit an act that violated conditions of your parole, determine if the acts are sufficiently serious to warrant revocation of your parole, and to determine if you should be held in prison pending further proceedings. The state, not you, has responsibility to show this probable cause to believe you violate one or more conditions of your parole. If I do not find probable cause or reinstate parole, which is release you, place you back on parole supervision. If I find probable cause and determine the act is sufficiently serious to warrant revocation, you may be held in prison pending further proceedings. Please note you've been referred by the Department of Corrections for diversion for substance abuse programming and treatment. If by the end of the hearing I determine that you should be held in prison pending further proceedings, I will provide additional information about the diversion process. You should know preliminary hearing is an adversarial proceeding, and anything you say at this hearing can be used against you. This hearing is being recorded. And then, so this is the procedure. I'm going to read you your rights. Then we're going to review the parole violation charge state appeals bringing against you. I will review and identify exhibits filed for the record. You will then have an opportunity to just issue probable cause and the severity of the allegations. At the conclusion of the hearing, I'll inform my findings, which are based on the available evidence. So do you have any questions about the purpose or procedure?
No, ma'am.
Okay. You have important rights. You have the right to have an attorney present. You have counsel here. You have a right to receive the written notice of charges of violation. Did you receive that written notice?
Yes.
You have a right to view the evidence against you, right to submit evidence for your case. At this hearing, right to call and examine voluntary witnesses or cross-examine adverse witnesses. Do you understand these rights and are you ready to move forward?
Yes.
Okay. So we will now review the charge state appeal is bringing against you. And the information. Yep.
If I may just interrupt, I apologize. We
Go
will be
ahead.
waiving the first portion of the hearing and going into the second portion for placement into the top program. Thank you.
Okay. So I'll accept the waiver of the first part of the hearing. I will note, I do make findings on drug testing based on exhibits A and G, as well as drugs, which is based on exhibits A, G, and F. And I do find the acts are serious enough to warrant revocation. So you have been referred by DOC for diversion from the revocation process for substance abuse programming and treatment. This means if you want to participate, apply, and I find that you meet the criteria, I can continue your case while you provide an opportunity to participate in the substance abuse programming and treatment in the correctional facility. If you successfully complete the programming and treatment provided, I will dismiss your case and order your parole reinstated. If you do not complete the programming and treatment provided, the board will schedule and convene a revocation hearing to determine if you violated conditions of your parole. If so, the hearing examiner would make recommendations regarding whether your parole should be revoked or if a sanction should be imposed. The decision to participate in diversion is voluntary. Do you understand the diversion process and do you want to apply for it?
Yes, ma'am.
Okay, so I'll now announce my findings with respect to your eligibility. If I determine you're eligible, I can accept your application and divert you from revocation. And I have reviewed all the relevant information. My finding is as follows. I find you have no pending misdemeanor or felony charges. I find that your discharge date is more than 60 business days from the date of your remand. I find there's evidence that you have identified substance abuse treatment needs. I find that substance abuse is reasonably considered to be a motivating factor in your alleged failure to comply with terms and conditions of parole. And I find there's some evidence that you have received or provided with an opportunity to receive substance abuse programming or treatment during your period of parole supervision in the community. So I have determined you are eligible for diversion for substance abuse programming and treatment. Before I accept your application for diversion, I ask that you indicate whether you understand the following by saying yes or no. I understand I will remain incarcerated while I receive programming and treatment, and that parole revocation proceedings may be delayed as a result.
Yes.
I understand that dismissal of my case and reinstatement to active parole supervision is not guaranteed and is conditioned upon my successful completion of the TOP program.
Yes.
I understand that ultimately DOC will determine whether I have successfully completed the TOP program.
Yes.
I understand that my participation in this process is completely voluntary.
Yes.
All right, so your application for diversion is granted. You're placed in treatment program by DOC and diverted from revocation for no more than 60 business days. So as long as you complete the program, I will have your parole reinstated after I'm notified. Just make sure you stay out of trouble, do not get DRs, and you complete it, and then you'll be back out there, okay?
Okay, thank you.
All right, so you're all set, sir.
All right, thank you.
Thank you. Good luck, Mr. Link.
Thank you.
All right. I'll see you back at 10:30.
Yes.
If it's the same one, yeah. Not a big deal.
Morning.
Hey, how you doing?
Good, how are you?
Doing all right. You looking for Shepard?
Yes, please.
All right. I told him to be down for 10 o'clock. I could try to see if he could come down a few minutes earlier, but it might take him a few minutes. I know he has to go get his clinic.
Okay, no problem. I'm a little early, so that's perfectly fine.
Okay, man.
Thank you.
You're welcome. Yeah. I know she gets she just ran down for 10 a few minutes ago. That was I hope Shepard down.
Hi. Can you hear me? Hello? Hello? Hi, I'm gonna run real quick to the bathroom. I'll be right back, okay?
We're not gonna start till 10 anyway, so you got plenty of time.
Thank you. hon.
There's no going to the bathroom. You stay in your spot and you take
Oh
care of business.
my God! Ow! Can I see your face, Al? Stand in front of the camera.
Catherine,
You knew it was you.
Al!
Catherine, what are you doing?
I'm trying to work. Let me see you. Come on, let me see you.
It's in there.
Oh my God, you look younger. You look so rested.
Well, that's what's the case.
The boys like the fountain of youth. You go over there and you get younger.
That's exactly what happens. Don't tell them.
That's our secret.
Yeah, don't tell
We
them.
are still connected to the live stream,
Yes.
everyone.
Oh,
Yes, we
okay.
are. Morning.
Good morning.
Mr. Shepard.
Yes, ma'am.
Okay, we're here today for your revocation hearing. I have your attorney here, as well as P.O. Montoya. So we are going to get started in 1 minute.
Okay.
Good morning, I'm P.O. Meisinger, hearing examiner for the Board of Pardons and Paroles. It's revocation hearing concerning Shepard Robert, number 266562. Today is December 10th, 2024. This hearing is being conducted via video at the BOP Central Office, New Haven Correctional Center. This is a public hearing. Public access to this hearing is available via video live stream. Can you please state me your full name and DOC inmate number for the record, sir?
Robert Shepard, 266562.
We have a parole officer present. Please identify yourself for the record.
Catherine Montoya.
And we have counsel here today. Please identify yourself.
Yes, Hannah Dean on behalf of Mr. Shepard. Good morning.
Good morning.
This is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of facts as to each of the charges against you. The state, not you, has responsibility to prove the allegations by a preponderance of evidence, that is, the better weighted evidence must establish that more probable than not the allegation is true. If I do not find that there is a preponderance of evidence to support a violation or one or more conditions of your parole, I'll reinstate your parole, release you, place you back on parole supervision. If I find you have violated one or more conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I'll make a recommendation as to appropriate sanction, and my recommendation be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing would be provided to justify additional confinement. So this is the procedure. I'm going to read you your rights. Then we're going to review the parole violation charge. State your PO is bringing against you. I will review and identify exhibits that filed for the record. The state will then have an opportunity to present a relevant testimony. After the state is finished, you will have the same opportunity. After considering all the evidence presented, I'll announce my findings. If I find that you have violated one or more conditions of your parole, the state will have an opportunity to speak to your background and history. After the state is finished, you will have the same opportunity. Do you have any questions about the purpose or procedure?
Not yet, I don't. Thank you.
Okay. Your important rights today, the right to have an attorney present. You have counsel here. You've received the written notice of charge of the violation. Did you receive that written notice?
Yes, I did.
You have a right to view the evidence against you. You have a right to submit evidence in support of your case. At this hearing, your rights call and examine voluntary witnesses and cross-examine adverse witnesses. Do you understand these rights and are you ready to move forward?
Yes, I am.
All right, so we now review the charge, state your PO is bringing against you, and the information underlying each charge. So PO Montoya, if you please read the charges.
Good morning. Charge 1, reporting. On 8/28/2024, you were directed to report to the Waived Parole Office on 9/3/2024. You failed to report on 9/3/2024 as instructed and all days thereafter. Several attempts to contact you were made with negative results. Your whereabouts in the community remain unknown until your arrest on 9/19/2024. Charge 2, program participation. You completed a phone screening with McCall Foundation on 8/14/2024. You completed your intake appointment for substance abuse on 8/27/2024. On 8/28/2024, you failed to attend your telehealth visit. On 8/29/2024, you failed to attend your appointment for medication assisted treatment. On 9/4/2024, you failed to attend your intensive outpatient programming. You failed to return to McCall Foundation despite multiple calls and direction from both your parole officer and program staff. You were negatively discharged from McCall Foundation on 9/13/2024. Charge 3, residence. On 9/4/2024, officers from the Waived Parole Office performed an attempt to locate your approved residence, yielding negative results. On 9/9/2024, this officer spoke to your approved sponsor, who reported that you moved out of your approved residence on 8/28/2024. She reported that she has not seen you since you moved out and is unaware of your whereabouts. You failed to provide this officer with verification of your new address. You moved your residence without approval from your parole officer. Charge 4, obedience to the law. On 9/19/2024, Windsor Police were called to Stop and Shop on a report of trespassing. Windsor Police found you outside the store and asked what your name was. You reported to Windsor Police that your name is Jonathan Sullivan, date of birth 4/11/1977, and refused to show your ID. Windsor Police asked you multiple times what your correct name is. You continue to report your name is Jonathan Sullivan. When Windsor Police informed you that you were going to be fingerprinted in order to trespass you from entering Stop and Shop, you then provided your real name of Robert Shepard, date of birth 4/11/1977. You were subsequently arrested and charged with 538-1678, interference with an officer. Charge 5, drugs. On May 30, 2024, you submitted a toxicology screening at Open Heart. You tested positive for cocaine and alcohol use. You signed a voluntary drug admission form. On 6/14/2024, you submitted a toxicology screening at Open Heart. You tested positive for cocaine use. On 6/18/2024, you submitted a toxicology screening at Open Heart. You tested positive for cocaine use. You signed a voluntary drug admission form. On 6/27/2024, you submitted a toxicology screening at Hartford Parole. You tested positive for cocaine use. You signed a voluntary drug admission form. On 8/27/2024, you submitted a toxicology screening at McCall Foundation. You tested positive for alcohol and cocaine use. On 8/28/2024, you submitted a toxicology screening at Waived Parole. You tested positive for cocaine use. You signed a voluntary drug admission form. Charge 6. No consumption of alcoholic beverages. On May 22, 2024, you signed special parole conditions, alcoholic beverage consumption. Throughout your period of parole, you are prohibited from the consumption of alcoholic beverages. You will be required to submit to random toxicology screening to monitor your compliance. On May 30, 2024, you submitted a toxicology screening at Open Heart, Halfway House. You tested positive for cocaine and alcohol use. You signed a voluntary drug admission form. On 8/27/2024, you submitted a toxicology screening at McCall Foundation. You tested positive for alcohol and cocaine use. Charge 7, no contact with co-defendants. On May 22, 2024, you signed a special parole condition, contact with co-defendant. Throughout your period of parole, you are to have no contact with Teresia O'Hara, the co-defendant of your offense. On 6/14/2024, you were issued a misconduct due to your parole officer seeing a picture of you and your co-defendant, Teresia O'Hara, at your son's graduation. You admitted you had contact with your co-defendant on 6/14/2024. Charge 8, mental health treatment. On May 22, 2024 and 8/16/2024, you signed special parole condition. You will participate in mental health treatment program, including monitoring for medication compliance with DEMA support. On 8/27/2024, you failed to complete your telehealth mental health prescriber appointment. You left McCall Foundation without completing the process for your mental health evaluation and intake.
Thank you. And the state has filed the following exhibits pre-marked for identification purposes as Exhibit A, remand in custody order B, parole conditions dated 5/22/24 and 8/16/24. C, parole violation report. D, notice of parole violation. E, Winston Police Report dated 9/19/24. F, misconduct report, cocaine and alcohol use drafted 5/30/24. G, voluntary admission form dated 5/30/24. H, retrotoxicology lab report positive for cocaine use dated 6/14/24. I, misconduct report, cocaine use dated 6/18/24. J, voluntary admission form dated 6/18/24. K, Redwood toxicology lab positive for cocaine use 6/18/24. L, misconduct report cocaine use dated 6/26/24. M, voluntary admission form dated 6/27/24. N, McCall Foundation toxicology report positive for cocaine and alcohol use dated 8/27/24. O, misconduct report cocaine use dated 8/28/24. P, voluntary admission form dated 8/28/24. Q, Premier Biopsy toxicology results dated 8/28/24. R, misconduct report violation of additional condition contact with co-defendant dated 6/14/24. S, McCall Foundation discharge report dated 9/13/24. T, email chain from Matt Foundation clinician showing Shepard was directed to complete intakes for substance abuse and mental health evaluation. U, revocation hearing summary dated 12/21/22. V, revocation hearing summary dated 6/26/23. W, revocation hearing summary dated 11/14/23. And Y is case notes entry dated 8/28/24. Did you receive notice of parole violation report, and those other documents I marked? Did you review them?
Yes.
And counsel has filed the following exhibit that's pre-marked for identification purposes as defense exhibit 1, list of parole accomplishments and future plans for parole reinstatement, and defense exhibit 2, which is a letter of support. Do you need to continue this hearing to obtain any additional evidence?
No, we don't.
We have no witnesses today. I will put on the record, I received an addendum from PCS. The addendum reported on 9/26/24. The charge of interfering with an officer resisting was nollied, and on 11/5/2024, the offender was convicted of larceny 6 and received an unconditional discharge.
I would just note as to the third addendum, I think that date is wrong. When I looked in judicial, I couldn't find it on 11/5. I believe it may have been a different date.
11/5 is a different date?
I don't believe the 11/5 date is correct for the conviction, for the conviction.
We'll just note the larceny 6 there was a conviction or unconditional discharge. So at this time, the state is going to have an opportunity to speak to any of the evidence submitted. I'm going to swear in Mr. Shepard as well as P.O. Montoya in case you do choose to speak today. So can you please raise your right hand? You solemnly swear, sincerely affirm, as the case may be, the evidence you shall give, sir, in this case, shall be the truth, the whole truth, and nothing but the truth, so help you God upon penalty of perjury?
I do.
All right. So P.O. Montoya, would you like to say anything in regards to the charges?
Yes. Shepard, this is his fourth violation of supervision while on parole. He has, as I explained, he has shown very little regard to taking his parole violation, parole supervision seriously. He is unable to come out to the community and complete any significant portion of his supervision in compliance. The minute that he comes out to the community, whether it's in a halfway house setting or the actual community setting, he will immediately start using drugs, and he will usually take off from his officer. He will stop answering the phone. He will cease all contact with his parole officer, and which is extremely difficult for us to create a treatment plan and be able to come up with a plan for him to remain out in the community. From the beginning, when I started supervising him, he was due to report on 8/27. He didn't report because he was completed his intake at McCall Foundation that he could have done the whole week before, but he didn't. I worked with him on that. I rescheduled him for the next day. He left McCall Foundation without completing the process because they scheduled him right on the spot to see a mental health professional for him to start his mental health, complete his mental health evaluation, and also, start medication if he needed or anything. He just left in the middle of the process. He reported to see me on the 28th. I pulled the urine. He was already dirty. He reported that he was stressed out because the sponsor that he was living at, he did not know. He had paid her $400 to agree to be his sponsor. He didn't know that she was being evicted and that she was on Section 8. He also reported that, I think when I went to serve him, he said that she was selling drugs and that he didn't feel comfortable living there. I said, well, why don't you find another place to live? Let's figure out. Of course, I'll work with you if you're 30 now. You know, you just came out, absolutely. And he was given reporting for September 3rd. He never reported. He called me. He's like, oh, I'm in Enfield. And then he stopped picking up the phone and he basically took off, which is what he always does. You know, this is his MO, just taking off as evidence in his prior parole violations that are included here. Spoke to the sponsor and she basically says that he moved out on the 28th. I wanted him to report because I had a halfway house lined up for him. I wasn't going to put him in jail or anything. I was actually literally just taking him off the community, put him back in a halfway house so he can continue treatment with McCall Foundation. He didn't report. And then when I kept calling, went to his house several times, I had no option but to declare an absconder. As I was writing the absconder warrant, I finally get a call from Windsor PD that he had been arrested for trespassing and giving a fake name. I'm just, you know, by the nature of his current charge right now, which is escape, he tried to escape from a court while he was being, you know, facing charges. And this is what he's doing, his special parole now. He's seeking for escape. And this is what he basically has continued doing on all his provisions. He just takes off and he ceases communication with all, you know, his officers. And when he does stay, he's just constantly in a state of violation. He's unmanageable in the community. He does not engage with the officer. He's shown unwillingness to follow his parole violations, to follow instructions. And I just don't understand. I also want to point out this list of exhibits and that was submitted by the lawyers, I guess, on their employment. Shepard, how come you didn't list your fiance? Because you told me you were working for her, putting together plans for kids on the autism spectrum. How come you didn't list?
I told you I was doing research, online research.
Yeah, no, you told me you told me you were putting plans for kids on the autism spectrum.
No, I was doing online research.
And I question you because I know for you to be able to do stuff like that, you need lots of qualifications, you need education, and I was questioning you as to why you were putting together. I just wanted to know, like, how come you didn't list that? How come you didn't list that as your employment? You have all these jobs here listed. None of these you can really prove. The same thing under parole accomplishments when it comes to the stuff that you reported with McCall Foundation. Again, you really only went there one time, completed half an intake and walked out. I just don't understand. And when he gets reinstated on this supervision, he is bound to do the same thing because he just refuses to engage with his officers. He refuses to follow his parole condition. He does not report. He was on the run for 7 months and he only got a 3-month sanction. That is unbelievable. This guy basically has gotten scot-free on 5 years of special parole supervision. He hasn't been compliant no more than 30 days each time. And you're here asking us to come out again. I don't understand. And my record shows that I work with everyone, sir. Everyone. I hardly ever violate anyone because I want to work with people. And I attempted to do that with you. And you never engaged with me, never picked up the phone, never wanted to follow your conditions.
So I'm going to let him, if you're all set, then I'll let them respond.
Go ahead.
Okay. So
first of all, I apologize.
If I may just, Mr. Shepard, I would just ask that we not say anything related to the charges here.
Yeah,
I would just note that a lot of this stuff I'm going to address in my arguments as far as the charges go.
Okay.
So
I would like to apologize for any inconvenience I caused you at all. I don't deny that I was in a lot of difficult situations and I made the wrong choices, but it was due to drug addiction. I mean, I don't have any other reason. I need help with drugs. I am the first one to admit that. And because of that, I make the bad choices. And when it comes to my job, I can't work with kids. I wouldn't tell you I worked with children because I'm not allowed to. And that was specifically her guidelines when she hired me, that it was gonna be only research per diem because she couldn't have me there for children being there and I have felonies. So I was never at her residence to do work. It was only online research. And it's just a bad situation. I mean, it's embarrassing and it looks extremely bad. And I acknowledge that 100%.
Okay.
And I just want help. I just want help with this treatment I've been dealing with for so long. I've been dealing with this addiction for so long. And I'm tired. I'm tired of it. And I make choices that I think are right due to my addiction, but then they end up violating my parole, like getting the heck out of there and going to Enfield, but I'm violating my parole at the same time. So I understand. I totally do. I don't deny any of that one bit. I just need more help than you can imagine. And my escape charge that I'm here for was originally a robbery. And I was in an extreme detox in court and there was an incident. So yes, they gave me an escape and they overpowered my robbery charges. But I apologize for any inconvenience. I apologize for the lack of being in a community. I've recently been doing lots of work that I'll get to when my lawyer's finished. I thank you very much for hearing me out. And I apologize to you once again, Ms. Montoya.
Thank you so much. Yeah, so just addressing the charges. I want to start with charge 3, which is the residence charge. This is an unfortunate situation. My client did have someone who he thought was a good, stable sponsor that he could go to in the community. He was under the impression that it would be a good support system. No drugs were in the home. It was a sober living environment. Unfortunately, when he did get there, understood that it wasn't that. It was unfortunately a bad environment and he needed to get out of there in order to avoid continued issues with relapse. At the preliminary hearing, my understanding is that Officer Montoya did testify that she had been feeling some concerns about that placement, but still approved it anyway. I think that is just worth noting because my client, unfortunately didn't have the knowledge that this is what was going on there. As to the charges 1 and 2, I will echo somewhat similar comments. I don't believe in either case my client was intentionally evading reporting requirements or IOP. He did indicate that in order to remove himself from the environment where he was faced with, issues regarding relapse and substance use concerns, that he did go somewhere that was a better fit. It sounds as though this issue was vocalized to his PO and they were trying to work on it, but I just want to note that I don't think it was an issue of him wanting to completely blow off IOP or blow off reporting. It was more of an issue with transportation based on where he was residing. As to obedience of the law, I would argue that the preponderance standard has not been met. No information has been submitted regarding any sort of conviction or anything with the interfering charge that was nollied in court. And there's no evidence submitted as to the other charge. We don't have a police report or anything of that nature. As to charge 5, no comments. As to charge 6, I just want to note that my client, I understand that there is a positive tox screen. However, he does not report at any point ingesting alcohol. He does not have any sort of indication when that could have happened. So I'm unsure why that came back positive. I just thought that was worth noting. For charge 7, the contact with co-defendants, he did have approval to attend a graduation. It was a graduation for his son, and this was a shared family member. My understanding is that the person he's supposed to have no contact with is the son's mother. We're unsure why she was included as a co-defendant because my understanding is she was not a co-defendant for the actual criminal charge, but he did have permission to attend the graduation. It was a situation where allegedly a family photo was taken. It wasn't just of my client and this individual. There were family members in the photo as well, including their son. And my understanding is that Parole was still working with him after this. This happened back in June. And then as far as charge 8 goes, mental health treatment, I would argue the standard hasn't been met. They're alleging here that he did not complete the intake process, but then in charge 2, program participation, it does say that he did complete an intake on 8/27. No additional information or exhibits have been submitted indicating that he didn't complete that. So I would argue that for charge 8, the standard hasn't been met. And then if needed at the appropriate time, I would like an opportunity to speak to background. Thank you.
Can I speak?
Sure, go ahead.
Okay, let's go back to these through the charges again. reporting. I will argue that he was well aware that he has to report. He's been on supervision for many, many years. Reporting can also be a phone call. He could call, he could find someone else's cell phone and communicate that he's stuck in Enfield. I do have a state assigned vehicle. I would have drove to Enfield to pick him up. He did not do that. He never called me. He never returned any of my messages. He knows that one of the primary functions of parole is for him to report to see his assigned parole officer, and he absolutely failed in these regards. And if he's anywhere within the state of Connecticut and he's stuck and he's unable to get a ride, all he has to do is get on a phone, call the Waived parole office. You can Google us real quick. If he doesn't have my cell phone number, I would have gone and picked him up. So I will absolutely argue that he was well aware of the fact that he failed to report and he is absolutely guilty of reporting. Program participation. Yes, on 8/27, he did complete a substance abuse intake. After he completed the substance abuse intake, he was told, wait for a telehealth with a mental health provider, because the mental health provider is done via telehealth. He did not wait, he walked out. And this is stated.
It was actually rescheduled to the next day.
No, that's not what I was told.
I'm sorry. I apologize.
That's fine, Shepard. I was told that you walked out. That's
Okay.
program participation for mental health. Residence, you were right. I had a lot of concerns about that residence. I did not think it was a good setting for him. But my agency overrides me because they met the standard that they're looking for, and the standard is not that high. So the woman was saying that yes, he could stay there. I did not think it was a good setting for him. So in that regards, I do agree with you. He absolutely should not have gone there. I have no power to stop his release. No power whatsoever. I did not think it was a good setting, but he wanted to go there, and I had to let him go there. However, when he came here on the 28th and reported that it was not a good setting for him, and he reported, first of all, he went there lying because he said that he was a friend, that she was a friend, and that he knew her. But then he comes over here and tells me, I have no idea who this woman is, and I pay her $400 to say that she's my friend and she could sponsor me. So this is what he told me and reported to me when he came to see me on the 28th. So I said, you have a week to figure out where you want to go, find me a sponsor, let's figure out how to get you out of the residence. Meanwhile, I case conference with my supervisor, set up a halfway house for him, just in case he's unable to get a sponsor so he can have a place. He never reported again. Let's go back to alcohol. He absolutely consumed alcohol. We have toxicology screenings that are attached to the evidence showing alcohol consumption. So whether it's a sip of alcohol or whether he got drunk, falling down drunk, it doesn't matter to me. The fact of the matter is there is a parole condition that states he cannot have any alcohol consumption, and I have actual toxicology screenings that went to a medical lab who confirmed he consumed alcohol. That is their part of the evidence. No contact with co-defendants. He was told before he left the halfway house, make sure that you don't have any contact with Teresa. He knew he couldn't have any contact with Teresa. Not only did he have contact with her, he took pictures with her and hung out with her. That's fine. So obedience to the law. He was outside Stop and Shop. He gave a fake name to the cops over and over again. He finally admitted, okay, this is my name. And then a few weeks later, he got served with a larceny. And I do have a copy of the police report right here. He was served with a larceny, and he did go to court and clear that charge. By the way, the person that he was arrested with, the female that he was arrested with, he was trying to tell me that he was going to put that lady as his next sponsor. And I was like, how are you going to be putting someone that is actively stealing from Stop and Shop as your sponsor? It's not a good decision. Consider a halfway house placement or get a pro-social sponsor. So again, this is all has to do with the fact that he is not focused on following his conditions, on following the rules, and he's just unmanageable in the community. I don't know which other way to say it. There's no guarantee that we're going to release him and that he's going to come back. There's none. Even if you put him on GPS, he can still cut it off. It doesn't matter. He has to have it within himself to follow the rules. if you had called me and told me I'm stuck in Enfield, I have no way to get down to Waterbury, you could have called me from anyone's phone. I would have gotten in my car during business hours. I would have gone and picked you up.
You can speak when she's done if you want to.
So I just, that's all I have to say. I have
Okay.
evidence. I have proven my case.
So
Respond.
you're,
Just a moment.
Hold on, your attorney wants-
I would like to respond. So as to charge 8, I just want to note, I understand that you're stating now that, you received a call and they told you X, Y, and Z, that he hadn't stayed to complete this session. However, he's stating something else and there's no evidence submitted here. There could have been evidence submitted if that was the case. You could have submitted a report indicating that from the program. Nothing has been submitted here to show that he did not complete that intake, which is what the ground says for that specific charge. So I would again argue that that standard hasn't been met for that specific charge. And as far as the obedience of the law, again, I just want to clarify, there was no conviction on the interfering charge. I understand that there may have been a police report submitted here in evidence, but he then went to court and there was a nollie for that charge, so there was no conviction there. And as far as the larceny 6 matter, I understand that you have the police report. However, that police report was not submitted today for evidence. So I would just argue for that the standard has not been met either. As far
I'm not charging him with that. I'm not charging him with larceny. Nowhere is that here. I'm not charging him with larceny. He's only charged under this parole violation. He's only charged with, the lying to the police about his identity. I have not charged him with larceny.
Is what my argument is. My argument is that that charge was nollied and there should not be a finding on that. Thank you.
Yeah, numbers. I want to go back to charge number 8. Please refer to Renato report that was done on dated 9/18 at the bottom. If you go to 8/27/2024, telehealth office visit, estimated time 25 minutes, no show. That is him failing to meet with the psychologist or psychiatrist that was going to complete his mental health eval. Go to 8/27.
it also says there was 2 urines at McCall when there was only 1, but that's not true.
If you go to 8/27, it says 8/27/2024, MCC 99214, telehealth office visit, 25 minutes, no show. That is him failing to sit down to meet with the psychiatrist or psychologist that was going to complete his mental health evaluation.
They told me to come back the next day at 4 o'clock.
You left, Shepard. You left. And again, in the preponderance of the things, yeah, sure, do want to find it on charge 8. I have a lot more other things to worry about it. Mainly how he will not stop using drugs and he will not show up to see his officer. That's my biggest concern. He will not follow his conditions.
Okay. So I don't need any more testimony. I've listened to testimony from both sides.
May I just say one thing, please?
What do you have to say that's new information that we did not discuss already? If it's new information, you feel free to state it right now.
Just wanted the $400 she claims I didn't know the person. I knew
Well,
her boyfriend.
that's the least of my concerns right now, is that you paid somebody $400 to live there.
And from a person claiming that she wants to help people over and over, and that people tell her that, she sure is trying to bury me right now. So I
We're
need to
not
read
being
my letter.
charged with giving somebody $400 to live. That's not part of this charges. So let me get to the charges right now.
I just
You
have
can
a
see
letter.
at this. There's a whole second part of the hearing.
All right.
I need to do this part of the hearing, the first part, which is regards to the charges.
Yeah, Mr. Shepard, we get an opportunity to speak depending on what she finds. And at that time, you'll be able to read that, okay?
Okay, thank you very much.
So I have noted all of the arguments on both sides. I've reviewed the arguments from the preliminary hearing as well, which I do consider going into this hearing. So I have taken consideration a lot of stuff already that had been said at the prelim. So I am going to announce my findings. So on that charge 1, I do find you violated condition of least direction reporting. This is based on evidence testimony provided, exhibits B and C that were provided. On charge 2, I do find you violated condition of least direction program participation based on the evidence that was provided, as well as testimony. This is exhibits B, S, and T. On charge 3, I do find you violated that condition of least direction residence based on the evidence provided, which is exhibits B and D, as well as testimony. On charge 4, I do find you violate conditional bail laws, obedience to the law based on the evidence that was provided, B and E. Although the charge is not, I do find that the behavior meets the elements of the charge based on the information that I have. On charge 5, I find that you violate conditional bail laws, drugs. This is based on the evidence that was provided, B, F through Q. Charge 6, I find you violate condition no consumption of alcohol based on the evidence provided, exhibits B, F, G, and N. On charge 7, I find you violate condition no contact with co-defendants. This is based on the evidence that was provided, B and R, well as testimony. On charge 8, I find you violate condition mental health treatment based on the evidence provided in support of the charge. It gives B, S, and T, as well as testimony that was provided. So that includes the fact-finding portion of this hearing. Before we make a recommendation, the state will have an opportunity to speak to your background and history. After the state is finished, you will have the same opportunity. This purpose part of the hearing is to help determine what outcome I will recommend. So, P.O. Montoya, I don't know if there's anything further you want to say in regards to anything else at this time.
Shepard, all I'm going to say is when you come back out on parole, because you're coming back out, is whatever officer you get, please, even if you did not follow your conditions, even if you please just report. Report and sit at the table so everyone can come out with a plan. The minute you cut off communication with your officer, all bets are off and there's nothing we can do. There's nothing. You losing your sponsor, we can work with that. You catching a minor charge, we can work with that. You relapsing on alcohol or drugs, we can work on that. You're homeless, we can work on that. But if you're not communicating with us, if you take off out in the wind, there's nothing we can do. That's the only advice I'm going to give. That is all.
I appreciate that because I was never aware that there was so many things that you would work with me about. I always was just scared and took off. So, and because I was using, I just assumed that I was automatically going to go back to jail. And I apologize for not being aware of those situations. Is it now time for me to read my letter?
Just a moment. I'm going to make I'm just going to read some stuff and then I'll give you an opportunity. So my client, Mr. Shepard's 47 years old. He was born in Springfield, Massachusetts, where he was raised until about 13 years of age. He lived after that in South Carolina and Florida, eventually moved back to Enfield, Connecticut with his father. He has a very strong support network in the community now, including his fiance, who's a board certified behavior analyst. She included a letter for Exhibit 2. Other supports are his mother and his 7 children, ages ranging from 27 to 12. Most recently, while on special parole supervision, he did utilize Open for Halfway House. He did successfully complete the App Foundation residential services as well in August of this year. He has a high school diploma, previously worked doing roofing and home improvement for the past 18 years. He had his own business, TNR Home Improvement. He also reportedly works some side jobs, previously held positions at Taylor Rental in Manchester, Concrete Support Systems in Windsor Locks, World Class Distribution, Trader Joe's Warehouse in Bloomfield. While on supervision, he did do that inpatient program at App, successfully completed it, did the screening. He stays at McCall and Waterbury, and then also was doing medication management. He reports from a primary care provider. While on parole, he was engaged in outpatient services previously at Intercommunity in Hartford, including individual therapy, medication management. He began working with them while at CPA Halfway House, also as Intercommunity as his primary care service. Upon remand to New Haven Correctional Center, he has successfully completed the Tier 1 program. He gets methadone treatment. Weaning off that, he is participating in methadone groups once monthly, medication compliant. He also has been doing a large amount of work himself, doing workbooks regarding addiction services and codependency to continue moving forward on his own, even though he may not, the programs while unsentenced and while in are somewhat limited. He is, I think filling in those gaps, doing his own work regarding those things. Upon reinstatement, a special parole, he would like to be placed in a halfway house. He would prefer New Haven as his first choice, somewhere that would be somewhat of a more supportive environment. He could start fresh. Second choice would be Waterbury. Eventually, he's hoping to end up in North Carolina with his partner down the road once he's able to establish a good track record of supervision in the community. He is interested in attending night school. He's wanting to move forward with studying addiction services. He's amenable to any sort of job opportunity available to him and was also wanting to start his home improvements but business back up in the future. He wants to make it clear he's amenable to all treatment recommendations. He's looking forward to getting back into a program. This includes but doesn't limit him to IOP, inpatient if needed, would step down to outpatient services in addition to 12-step meetings. I would ask that he be released as soon as practicable. He's been incarcerated now for 3 months. But in that time, like I said, he's done a lot of work on himself to try and identify what needs to change in order to be successful in the future. With the help of his support system, including his fiance, he's gained a lot of insight into the ways addiction impacts him in his life. And he's been able to identify what he needs to do moving forward to maintain sobriety. His primary hopes to return to the community so that he can continue engaging in treatment for his addiction and eventually put that life behind him and move forward. I would argue incarceration alone isn't serving that purpose. He'd like the opportunity to get back into the community to focus on treatment and sobriety. And he does have a letter that he wishes to read at this time.
Go ahead.
Okay. Incarceration. I have used this time to focus and work on myself, very much so. I've come to realize that for the longest time throughout my life, I've been in complete denial about my addiction. I've been living a life like I was immune to it. Or maybe I thought if I admitted it, it sounded weak. Either way, it has caused me years of pain and prison time. Now, regardless whether I hit rock bottom or just became tired, for the first time in my life, I've come to a point where I'm not in denial, and I'm the first to admit that I need all the help I can get. Because of that, and because of that recent reality check, I have taken a lot of steps to improve myself, as well as strengthen myself so I can be better prepared whenever my next release may be. I completed the group called Tier 1. It just so happens to be the only one available at this facility at this time that doesn't have a long waiting list. I also have started therapy and studying through my fiance. It just happens to be certified behavioral analyst, which makes me pretty lucky, I guess. Anyways, her and I have had daily conversations on ways to improve and prepare for a life of independence and sobriety. She has taught me so much, as well as send me pamphlets and study to complete and mail back to her, which these are the pamphlets, just showing you, they're all completed in full. Once released back to the community, I will continue treatment very aggressively, as well as taking parental classes to help be a better father to my children. I will also be obtaining a sponsor, as well as completing intensive outpatient treatment. Whether I'm supposed to or not, it's going to be voluntary. I also have a bigger support system than ever before. My mom, my daughter, my dad, my fiance, they're all helping with basic needs like clothing and phone, all the little things that typically overwhelm me and cause relapse. With all of this said, I really hope that I can be given the chance to prove that it's treatment I need and not prison time. I've done enough prison time in my life, and it's always the addiction that gets to me every time. Thank you very much for your time and the opportunity to show I've been bettering myself. Have a wonderful day. Thank you. Now, I forgot to write. I would actually encourage, when I'm released, there's no evidence that I would cut a bracelet off. I've actually been on them before and I've completed it successfully. I would like to have a bracelet, to be honest with you, because I need to focus solely on treatment for a certain period of time until I'm able to successfully and accurately be in the community, with knowing that I'm not going to use 100%. Thank you very much.
Thank you for your statement. All right. So I've listened to testimony from the state as well as counsel. I appreciate your statement. I am going to reiterate on the record a few things. So you were in the community for less than 4 months while you were, after you were last reinstated. This is your, as was stated before, your 4th parole violation. You do have 2 prior absconding violations as well as a criminal violation. And unfortunately, you keep this pattern of absconding and then you're coming back with criminal charges again, but you have another conviction now. You also receive misconducts. You have 5 years special parole, so you're on parole until 2027 in August. So you still have a ways to go, and you're never going to finish like this, like Theo Montoya has stated.
I'm fully aware of that, and it's become a big reality check in the last few months. And
Okay.
absolutely right.
You have, according to our records, failed 4 out of 7 past community releases. And you have a history, obviously you're on parole for escape first. So it is concerning that we can't get you the treatment you need because you keep leaving, and you have done this for so many years that it is a concern. Because we can't do anything when you leave. And you know this, you've known this for years. You've known this since you've been on supervision since 22 of January. So it is very concerning. And, you know, your officers have tried to work with you. This is 8 violations is a lot. And no, I'm not asking for any input on this. This is me explaining this to you.
Okay,
That there's no improvement since you started parole. You come back with new charges, you're leaving. It's a lot. And, you know, I'm glad that your statements that you're maybe starting to understand this, but I think you have a ways to go to understand what negative impact you're putting on yourself, that not allowing yourself to do treatment. You come here saying you want treatment. We tried to give you treatment so many times, and it's hard because our arms are tied behind our back because there's nothing we can do for you. So I'm hoping that this time you are going to understand why you're in there, that this is a choice you made to not do these behaviors anymore, because you're old enough now. I mean, you should understand what you're doing to yourself and what you're doing wrong. You're an adult. You should know that these choices you're making out there are in no way beneficial to you, and you're holding yourself back as well as your family.
I do acknowledge that, and I'm extremely focused right now, and you're right. It took me a while to acknowledge that.
Okay, so and your officer has recommended a 2-year sanction, which is understandable. Based on this information, I am going to recommend that parole be revoked to be reparoled for November 19th of 2025. This is about a year and a 2-month period of confinement as a sanctions, about a year from like around now, a little short of that. I'm going to recommend the following parole conditions: halfway house placement, no consumption of alcoholic beverages, mental health treatment, no contact with your co-defendant, Teresa O'Hara, and a general no contact with Home Depot store in West Hartford, Connecticut. I'm going to present this to the board on December 19th. I'm trying to give you another chance to go back out there instead of revoking your parole completely, because I want to give you one last opportunity. This is up to the parole board though. So they're going to review this on December 19th. They're going to make the final decision. So they can agree with me for the reparole date of 11/19/25. They can make that shorter, or they can also revoke your special parole. So it's going to be up to the parole board. You're going to get it in writing about a week after 12/19, or you can speak to your attorney and they can let you know what their decision is. But I just hope you get the treatment in there before you come back out, and, you know, you better head on your shoulders. Okay.
I'll set up a call with you, sir, to discuss.
All right.
Okay. So you're all set, sir. I wish you the best of luck on everything.
Thank you. Have a good day.
Thank you.
Thank you, Pio Montoya.
Rob, what hearing do you have?
I have Delgado. He was bumped from 9:00 a.m. until now.
I'm going to do Delgado and then go down the list. Yeah, Delgado got bumped from Hartford, so I'm going to try to have him come in first, and then go straight down the list for Smith, Wells, Collette, and Bennett.
Okay.
You want Delgado first? Good morning.
Yes, can I please see Delgado, and then I'll go straight down the list: Smith, Wells, Collette, Bennett.
Okay, got you.
Thank you.
You're welcome. Delgado. I'll be right in this room here.
Good morning, Mr. Delgado.
Good morning.
Morning, we're here for your preliminary hearing, so we're going to get started with that, okay?
Okay.
Good morning, I am P.O. Meisinger, hearing examiner for the Board of Parties and Paroles. This is a preliminary hearing for Delgado, Nisaiah, number 436653. Today is December 10th, 2024. This hearing is being conducted via video at the BOPP Central Office in Osborn Correctional Institution. This is a public hearing. Public access to this hearing is available via video live stream. Can you please state your full name and DOC inmate number for the record?
Nisaiah Delgado, 436653.
Thank you. We have counsel here today. Please identify yourself.
Yes,
Yes.
Public Defender Robert Famiglietti of the Parole Revocation Unit. Good morning.
Thank you. So this is a preliminary hearing, which is the purpose under Connecticut law. It's to determine if there is probable cause to believe you commit an act that violated conditions of your parole, determine the act sufficiently serious to warrant revocation of your parole, and to determine you should be held in prison pending further proceedings. The state, not you, has responsibility to show that there is probable cause to believe you violated one or more conditions of your parole. If I do not find probable cause, I'll reinstate your parole, which means releasing you, place you back on parole supervision. If I find probable cause and determine the act is sufficiently serious to warrant revocation, you may be held in prison pending further proceedings. You should know preliminary hearing is an adversarial proceeding. Anything you say in this hearing can be used against you. This hearing is being recorded. So this is the procedure. I'm going to read you your rights. Then we will review the parole violation charge and state your appeal is bringing against you. I will review and identify exhibits filed for the record. Counsel will then have an opportunity to address the issue of probable cause and the severity of the allegations. At the conclusion of the hearing, I'll inform my findings, which are based on the available evidence. Do you have any questions about the purpose or procedure?
No, ma'am.
Okay. You have important rights today. The right to have an attorney present. You have counsel here. You have right to receive the written notice of charges of violation. Did you receive the written notice?
Yes.
Okay. You have a right to view the evidence against you. You have a right to submit evidence in support of your case. At this hearing, right to call and examine voluntary witnesses and cross-examine adverse witnesses. Do you understand these rights and are you ready to move forward?
Yes.
All right, so now review the charge, the state appeals bringing against you, and the information underlying each charge. So charge 1, release direction GPS, your charging officer, report 11/16/24, approximately 2:36 p.m. You removed your GPS monitoring unit from your ankle and disposed of it at an unknown location. This is in violation of your signed GPS monitoring agreement. I will remain on GPS monitoring for a length of the time determined by a parole officer and will not remove the GPS tracking device or strap my ankle without prior permission from a parole officer. Charge 2, no bail laws drugs. Your charging officer reported on 11/5/24, use cocaine and alcohol. Charge 3, halfway house placement. I broke this down into, I have 7 different paragraphs I separated into. So part 1 states on 10/16/24, you signed out of the Watkinson halfway house to go to a dental appointment. You signed out at 9:25 a.m. with the return time at 12:15 p.m. You failed to return at your approved return time. Watkinson and halfway house staff contacted the dentist's office and they state that you left the office at 11:30 a.m. At 1:03 p.m., you called the program, reported that you were in downtown Hartford waiting for a bus. You returned at 2:13 p.m., leaving you on accountable community for 1 hour and 58 minutes. You told staff, I decided to go for a long walk. This is in violation of your signed halfway house agreement. Specifically, I will only go to locations indicated on approved community pass. Part 2 states on 10/22/24, you were seen entering the halfway house bathroom with another offender. After some time, staff knocked on the door and asked you and the offender to come out of the bathroom. After subsequent pat search, you were found with marijuana in your pocket. This is in violation of our signed halfway house agreements. Specifically, I will not consume and possess alcohol or marijuana in the halfway house. Part 3 states on 10/30/24, you signed out of the Watkinson halfway house to go to the village for treatment. You signed out at 9:37 a.m. with an unexpected return time of 12:30 p.m. You called the Watkinson halfway house at 1:05 p.m. to say that you just got on the Albany Ave bus and should be back in 25 minutes. Watkinson halfway house staff called the village and stated you finished up your appointment on time, which gave you enough time to return to Watkinson for 12:30 p.m. You returned to the Watkinson halfway house at 1:52 p.m., leaving you on accountable community for 1 hour, 22 minutes. This is a violation of signed halfway house agreement. Specifically, I'll go to locations indicated on approved community pass. Part 4 states on 10/30/24, you returned late from your pass. Halfway house staff informed you that you should have been back at the halfway house by 12:30 p.m. You responded, y'all get on my nerves. I'm leaving in a week. I don't care about you. Nothing. P.S. Stickles told me I'm out of here. As you walk up the stairs, you said, I'll slap the shit out of any one of them bitches, referring to both staff members on duty. This is in violation of our signed halfway house agreement. Simply, I will treat others with respect, not engage in verbal or physical altercations with other offenders, staff, or third parties. Part 5 states on 11/1/24 at 11:55 a.m. you exited the Watkinson halfway house without authorization. At 1:30 p.m. an emergency house count was conducted, at which time it was determined that you were not in the building. Upon reviewing the cameras, determined you walked out of the front door immediately after 11:50 a.m. house count. Watson halfway house staff attempted multiple times to call you on your phone, no answer. PO Stickles attempted to locate you on 11/5/24, calling your phone number, your mother's phone number, Hartford Hospital, St. Francis Hospital, and Hartford PD. You made no efforts to return or contact your parole officer until 11/6/24 when you turned yourself into the Hartford Parole District Office. This is in violation of signed halfway house agreement specifically. I will not leave the physical confines of halfway house unless authorized by program staff or parole. Part 6 states 11/12/24, you signed out of the Stein halfway house to go to the Hartford Hospital. You signed out at 5:27 p.m. with an undetermined return time. Stein halfway house staff called Hartford Hospital to confirm you were there. Halfway house staff were told by the hospital staff that you left Hartford Hospital without being seen by a physician. The PO was notified and immediately reviewed your GPS points to place you at 11 Benton Street, which the PO knew to be a family member's residence. You do not have permission to be at the residence. This is in violation of signed halfway house agreement. Specifically, a one-go location indicated on approved community pass. Part 7 states on 11/16/24, you signed out of the Stein halfway house to go to the Hartford Hospital. You signed out 8:15 p.m. with an undetermined return time. Stein halfway house staff called Hartford Hospital to confirm you were there, and halfway house staff was told by the hospital staff that you left Hartford Hospital without being seen by a physician. This PO was notified, immediately reviewed your GPS points, which placed you at 11 Benton Street, which this PO knew to be a family member's residence. You do not have permission to be at this residence. Over subsequent days, this PO attempted to locate you via calls to your emergency contact, local hospitals, police departments with negative findings. Your whereabouts in the community were unknown until you were located and detained by parole on 11/19/24 at Hartford Hospital in the city of Hartford. This is in violation of your signed halfway house agreement. Specifically, I will not leave the physical confines of the facility or the property thereof except for traveling to and from work and or as authorized by facility or parole and community services division rules. And the state has filed the following exhibits that are pre-marked for identification purposes as Exhibit A, notice of parole violation. B, notice of parole rights. C, remain actual custody order. D, PCS signed conditions. E, halfway house agreement. F, GPS monitoring agreement. G, Watkinson halfway house disciplinary report. H, offender misconduct. I, Watkinson half house disciplinary report. J, misconducts. K, Watkinson halfway house incident report. L, offender misconduct. M, Watkinson halfway house incident report. N, community solutions absconder report. Exhibit O, voluntary drug admission. P, premier biotech lab toxicology lab reports. Q, offender misconduct, as well as R. S, Stein halfway house residential disciplinary report. T, voluntary drug admission. U, Allied Universal Electronic Monitoring Report. And V, Stein halfway house residential incident report. W, Allied Universal Electronic Monitoring Report. And X is parole violation report. Did you receive notice of parole violation report, and those other documents I marked, and did you review them?
Yes.
Yes.
Okay. Do you need to continue this hearing to obtain any additional evidence?
No, we do not.
We have no witnesses today. So now is your opportunity to respond, well, defense opportunity, if you'd like to testify right now in regards to the charges.
Yes, please.
Go
So we have
ahead.
no comment. We have no comment as to probable cause regarding charge 1. As to charge 2, and then charge 3, parts 1 through 5. I'd like to draw your attention to exhibits D and E.
You said this
D,
is charge 2 or charge 3?
charge 2, all of charge 2, because it occurred on November 5th prior
mean
to
part
his
2?
signing.
Oh, you mean the drug charge?
The drug and cocaine
Okay.
charge.
Okay.
That occurred prior to his signing his halfway house agreement and prior to signing his statement and understanding and agreement conditions of parole, Exhibit D. Exhibit D was signed on November 7th, 2024, which is after that conduct, and it was after the conduct in sections 1 through 5 of charge 3. So I don't believe probable cause can be met. I don't believe the conditions or nor the elements are met. And as to charge 2 and charge 1 through 5, charge 3, parts 1 through 5, Exhibit E clearly states that he signed the halfway house agreement on November 6, 2024, which was after parts 1, 2, 3, 4, 5 of charge 3 and all of charge 2. As to the seriousness of the allegations, I don't believe these allegations are sufficiently serious enough to go forward with a revocation hearing. I don't believe they're serious enough to warrant further incarceration. We don't believe further confinement is necessary or appropriate. Thank you for your time and consideration.
Thank you.
You're welcome.
Right, so I'll be right with you with my findings. Right, so regarding charge 1, I make a finding of probable cause, restress and GPS based on the evidence that was presented, D, F, and W. On charge 2, I make a finding of probable cause of bail laws drugs based on the evidence presented, O, P, and Q, and no finding on the alcohol use. That doesn't meet the elements. It is common knowledge and a law that you can't use for being in possession of cocaine. So I do make a finding regarding that charge and your drug use. And regarding charge 3, halfway house placement, I do make a finding of probable cause on parts 6 and 7. I do not make a finding on parts 1 through 5 as there are no signed parole conditions or halfway house agreement conditions signed prior to those incidents occurring, or the alleged incidents. So regarding part 6, this is based on exhibits D, E, S, and U. And regarding part 7, I make a finding on that was based on exhibits D and E. I will put on the record that you were only in community for about a month and 10 days before you were returned to custody on discretionary parole. And you were placed in 2 halfway houses while you were out there in this short amount of time, and you left both of them. So based on that, I find the acts are serious enough to warrant revocation. Attorney should be detained while you wait for your rep hearing. These are technical violations, so that means I have 16 business days from your return to remand date to schedule your hearing. So I will schedule you within the next month or 2, probably 2 months, probably January or February. It will bring you back, determine if there's a violation or not. Okay?
Thank you.
Okay.
Sir, if you have any questions, just give me a call, okay?
Okay.
Thank you. Thank
right,
you
you're
very
all
much.
set.
Have a good day.
Me too.
Thank you, Attorney Famiglietti.
You're welcome. Thank you very much.
Have a good day.
You too.
And you can go back. You're welcome.
Smith?
Yes.
Morning, sir. We're here today for your revocation hearing.
Mm-hmm.
So I have your attorney here, so we're going to get started with that.
Okay.
Good morning, I'm P.O. Meisinger, hearing examiner for the Board of Pardons and Paroles. It's revocation hearing starting Smith Christopher, number 213535. Today is December 10th, 2024. This hearing is being conducted via video at the BOPP Central Office in Osborn Correctional Institution. This is a public hearing, public access. This hearing is available via video live stream. Can you please state your full name and DOC inmate number for the record?
Christopher Smith, 213535.
You have counsel here today. Please identify yourself.
Hannah Dean on behalf of Mr. Smith. Good morning, sir.
Morning.
So this is a revocation hearing to determine whether you have violated conditions of your release. I will review and make findings of facts to each of the charges against you. The state, not you, has responsibility to prove the allegations by a preponderance of evidence, that is. The better read your evidence must establish that more probable than not the allegation is true. If I do not find that there is a preponderance of evidence to support a violation or one more conditions of your parole, I'll reinstate your parole and release you, place you back on parole supervision. If I find you have violated one or more conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I'll make recommendation as to appropriate sanction, and my recommendation given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing would be provided to justify additional confinement. So this is the procedure. I'm going to review your rights. Then we're going to review the parole violation charges, state your appeals rain against you. I will review and identify exhibits filed for the record. Counsel will then have an opportunity to present a relevant testimony. After considering all the evidence presented, I'll announce my findings. If I find you have violated one or more conditions of your parole, counsel will have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure?
No.
You have important rights today. Rights to have an attorney present. You have counsel here. You have right to receive the written notice of charges of violation. Did you receive that written notice?
Yes, I did.
Okay. You have a right to view the evidence against you. Right to submit evidence to support your case. At this hearing, right to call and examine voluntary witnesses and cross-examine diverse witnesses. Do you understand these rights? Are you ready to move forward?
Yes.
All right. So we'll now review the charge. State your appeals rain against you and the information underlying each charge. The charge 1 under bail laws, obedience to the law, you're charging all support on 2/22/24. You're found in possession of 7 smaller clear plastic bags of crack cocaine on Laurel Place Apartments by members of the Bridgeport Police Department. Also, members from Bridgeport PD converged on the vehicle you were operating. You accelerated and reversed into the front bumper push bar of the task force officer Ben's police vehicle in an attempt to elude task force officers. Subsequently, this led you to being arrested and charged with possession with intent to sell narcotics, interfering with an officer. Your actions violate parole condition number 2, obey all laws. Charge 2 under obey all laws, drugs. Charging Osborn on 2/22/24 while being patted down for officer safety, the presence of weapons and illegal substances by members of the Bridgeport PD. It was discovered that you were in possession of 7 smaller clear plastic bags of crack cocaine. Charge 3 under conditions no driving. Your charging officer reported on 2/22/24. You were found to be an operator of a blue Honda Fit bearing Connecticut registration ending in 1751 while task force officers were conducting a motor vehicle stop for suspected drug sales. Part of your additional parole condition states that you are prohibited from operating a motor vehicle. And the state has filed the following exhibits that are pre-marked for identification purposes as Exhibit A, CT conditions of parole, B, CT board of parole remand and custody order, C, notice of parole violation, D, parole violation report, E, Bridgeport police report, and F is parolee rights. Did you receive notice of parole violation report, and those other documents that I identified, and did you review those?
Yes, I did.
And council has filed the following exhibit pre-marked for identification purposes as Defense Exhibit 1, list of parole accomplishments and future plans for parole reinstatement. Do you need to continue this hearing to obtain any additional evidence? No. Okay. Do you not have any witnesses? I'm going to put on the record, I received an addendum from PCS, the addendum report on 10/3/2024. You were convicted of sale of hallucinating narcotics, received a 16-month jail sentence. I have an EOS date on that sentence of 6/21/2025 with a TF of 10/20/2024. So now is now defense opportunity. If you'd like to speak at this time?
Thank you. As to the first charge, no comments as to the preponderance standard. I just want to note that that was an Alford plea and all other charges were nollied. As to charge 2 drugs, I would argue that the standard hasn't been met for that charge. The alleged drugs were just field tested. There weren't any confirmatory tests that were put into evidence. We don't have the results of the field test either. We just have the police report that has a note in it regarding that. So I would argue that the preponderance standard hasn't been met for that. And for charge 3, no comments. I do just want to note that my client does possess a valid driver's license. I understand that may be a parole condition. We just wanted to make clear that he does have a valid license. Thank you.
Right, so what I'm going to do next is I'm going to announce my findings. So on that charge 1, I find you violated obedience to the law. This is based on your conviction of possession with intent to sell hallucinating narcotics, received a sentence of 16 months jail. On charge 2, I do find you violated conditional bail laws drugs. This is based on your conviction of possession with intent to sell hallucinating narcotics and evidence that was provided in support of that charge, exhibits A, D, and E. On charge 3, I do find you violate condition no driving based on the evidence provided in support of the charge, exhibits A and E. So that includes fact-finding portion of the hearing. Before I make a recommendation, council will have an opportunity to speak to your background and history. This purpose part of the hearing is to help determine what outcome I will recommend. So if you would like to at this time.
Thank you very much. Mr. Smith is 53 years old, born and raised in Stamford, Connecticut. He has a good support system, including mom, sister, niece, nephew. They all reside in the Stratford area. He has a high school diploma. Upon release previously to special parole in December of 2023, he successfully completed Connecticut Renaissance's Maple Street halfway house in Bridgeport. He was there for approximately 10 months. He then transitioned to Park Place Sober House in Bridgeport, where he resided for 1 month until he became self-sponsored in February of 2024. Until he was then self-sponsored until he was remanded in February 24. He was employed by Connecticut Distributors, Inc. in Stratford, by a Hamilton Connections temp agency in Milford. He remained there for approximately a year and was due to be hired full-time. Reportedly successfully completed weekly outpatient substance use programming at Connecticut Renaissance in Bridgeport. Prior to his remand, he was on a medium contact schedule, and upon remand, since getting to Osborn, Mr. Smith has been working in the kitchen and is on the wait list to start Tier 2 programming. For future plans, upon reinstatement of special parole, he'd like to be placed at a halfway house in the Bridgeport area due to previous success. After successfully completing the halfway house, he would then like to go to a sober house. He is eager to return to Hamilton Connections temp agency in Milford. He's hoping to get placed back at Connecticut Distributors. He was due to start being full-time there, so I think he's hoping to get back to that so he can be full-time in the future. He's also wants me to let the examiner know that he's amenable to any sort of treatment recommendations. He also wants to complete successfully outpatient substance use treatment. I would argue at this point that he's been incarcerated for 10 months. I would ask for the soonest possible release date. I think that that is sufficient. The TAS date has already passed that he would be eligible, and it sounds as though he has a good support system going forward. So I would ask that. Thank you very much.
Thank you. So I'll be right with you with my recommendation.
Okay.
I'm gonna put on the record, I did review the evidence and I have listened to testimony today. I see you were on parole for about a year prior to coming back here on these new drug charges. Unfortunately, back in 2002, you do have a prior criminal violation for the same type of behavior, the same charges, selling drugs on special parole. Unfortunately, you have a history of selling drugs. And you have failed 4 out of 5 past community releases in the community. Based on this information, as well as testimony today and your new conviction, I am going to recommend that parole be revoked, be re-paroled for June 21st of 2025. This is the U.S. date on that new conviction, which is approximate 1 year and 4 month period confinement as a sanction. I recommend the following parole conditions: halfway house placement in Bridgeport, preferably an operation of a motor vehicle. My findings will go to the parole board on December 19th. So the board's going to make a decision on that day. They can lessen it as soon as 12/19. They can revoke all your special parole. I'm trying to give you one more opportunity to go back out before you're off supervision completely. Hopefully you can get employment or do something that's going to prevent you from selling drugs again. And I hope you make better choices in the future. But you're all set for today. You're going to know, you'll get it in writing from the parole board a week after December 19th. And you can speak to your attorney as well regarding what the decision is that day.
Okay.
Okay? Do you understand? Do you have any questions?
No.
Okay, so you're all set, sir.
All right, thank you.
Good luck.
Thank you. I'll talk to you soon,
Bye-bye.
Mr. Smith.
Okay, bye-bye.
Much.
Attorney Jones, are you there? Mr. Wells?
How you doing?
Morning, sir.
Morning.
We're here today for your revocation hearing. So we're going to get started with that. Good morning, I'm P.O. Meisinger, hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Wells Tyson number 344057. Today is December 10th, 2024. This hearing is being conducted via video at the BOPP Central Office at Osborn Correctional Institution. This is a public hearing. Public access to this hearing is available via video live stream. Can you please state your full name and DOC inmate number for the record?
Tyson Wells, 344057.
And you also have counsel here today. Please identify yourself for the record.
Yes, thank you. Attorney Sonia Jones, Public Defender's Office, Parole Revocation Unit on behalf of Mr. Wells.
This is a revocation hearing to determine whether you have violated conditions of your release. I will review and make findings of facts to each of the charges against you. The state, not you, has responsibility to prove the allegations by a preponderance of evidence, that is. The better weighted evidence must establish that, more probable than not, the allegation is true. If I do not find there is a preponderance of evidence to support a violation of one or more conditions of your parole, I'll reinstate your parole, which is releasing you placed you back on parole supervision. If I find you have violated one or more conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I'll make a recommendation as to appropriate sanction, and my recommendation will be given to a panel for final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing would be provided to justify additional confinement. So this is the procedure for today. I'm going to read you your rights. Then we're going to review the parole violation charges state your PO is bringing against you. I will review and identify exhibits filed for the record. Counsel will then have an opportunity to present all relevant testimony. After considering all the evidence presented, I'll announce my findings. If I find that you have violated one or more conditions of your parole, counsel will have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure?
No.
So your important rights today, the right to have an attorney present, you have counsel there. You've received the written notice of charges of violation. Did you receive the written notice?
Yes, ma'am.
You have a right to view the evidence against you for the hearing, the right to submit evidence in support of your case. At this hearing, the right to call and examine voluntary witnesses and cross-examine adverse witnesses. Do you understand these rights and are you ready to move forward?
Yes, ma'am.
All right, so now review the charge the state appeal is bringing against you and the information underlying each charge. Charge 1, obey all laws, obedience to the law. You're charging Osborn on 9/5/24. You observed working on a car by Bridgeport Police. During the police investigation, the police discovered the vehicle you were in possession of was stolen. You were subsequently arrested and charged with larceny of motor vehicle, larceny fourth. This arrest led to your probation being violated on 9/17/24. Warrant for VOP was issued on 9/17/24. On 10/1/24, you're involved in a minor physical and verbal argument with your girlfriend. Ultimately, you were charged with breach of peace. And the state has filed the following exhibits that are pre-marked for identification purposes as Exhibit A, CT conditions of parole, B, remand custody order, C, notice of parole violation, D, parole violation report, E, Bridgeport police report, 9/5/24, F, violation of probation warrant, 9/17/24, and G, Bridgeport police report, 10/1/24. Did you receive notice of parole violation report, and those other documents I marked, and did you review them?
Yes.
Council has filed the following exhibit pre-marked for identification purposes. Defense Exhibit 1, list of parole accomplishments and future plans for parole reinstatement. Do you need to continue this hearing to obtain any additional evidence?
No.
We don't have any witnesses. I did receive an addendum from PCS, which I'll put on the record, which states on 11/5/2024, you were convicted of larceny of motor vehicle. You received a 3-year jail sentence, executed suspended after 6 months with 3 years probation, and all other charges were nollied. I have an EOS date on that charge of 4/8/2025 with a PED date of 1/8/25. The TS date of 25.
I'm sorry, what was the end of sentence? I missed it.
4/8/25.
4/8, okay.
So now I'm gonna turn it over to counsel. If you'd like to say anything at this time?
Yeah, so just by way of comments, and I know the addendum does not indicate the disposition of the violation of probation, but they do include the fact that he was served with a violation of probation warrant, which was based on the conduct that's alleged here as part of this parole violation. So I want that to be clear and included within this violation, that my client did dispose of that case on the same day that he disposed of the larceny of a motor vehicle matter. And on that violation of probation, he received a 6-month sentence on that charge, and that was to run concurrent to the other charge for a total effective sentence of 3 years, execution suspended after 6 months, 3 years of probation. So just for clarification purposes. And then just by way of comments in regards to how the state and defense counsel came to that disposition. So it's my understanding that my client and his mother traded a vehicle for one vehicle for another vehicle, and then the car came back stolen. The individual that he traded the car with did go into court, and I did get this information from defense counsel in court, did go into court, did discuss this with the prosecutor, and did indicate that he did trade this vehicle. However, I think it came out that that individual did not have the authority to do that. My client did enter into this plea agreement, however, because he wanted to dispose of the case. He entered it under the Alford doctrine. He wanted to get to parole, to have this hearing, to get back out into the community. The court ordered no restitution in that matter. So I think that's important to note. And those will be my comments in regards to the charges. Thank you.
Thank you. Right, so what I'm gonna do next is I'm going to announce my findings. So on that charge 1, I do find you violate condition obey all laws, obedience to the law, based on your conviction of larceny of motor vehicle, received a sentence of 3 years jail, execution suspended after 6 months with 3 years probation. Also based on exhibits A, D, and E that were provided by the state. So that includes the fact-finding portion of this hearing. Before I make a recommendation, counsel will have an opportunity to speak to your background and history. This purpose part of the hearing is to help determine what outcome I will recommend. So if you would like to at this time.
Yes, thank you. My client's 35 years of age. He's single. He has 6 children, and a 16-year-old, 17-year-old, 18 months. He does have stepchildren as well. He's engaged to his fiancee. She resides in Bridgeport. He has his GED. He completed 1 semester at Three Rivers Community College. He was in the community for approximately 29 months prior to this violation, and I believe this is his second violation. He was GPS compliant for 2 years. He completed programming that's inclusive of the Explorer 26-week domestic violence program. He was gainfully employed, 2 jobs. He was working at Hartley and Parker Limited, which is in Stratford, for approximately 1 month. And then after that, he was working at John DeGrand and Sons in West Haven, and he held that employment for over 2 years. And that employment only stopped because he was involved in a car accident and suffered some injuries, which prevented him from continuing his job duties. We would be asking, and again, I would just point out in regards to the case that was disposed of in court, he did receive that suspended sentence. He is eligible to TS on that matter on January 8th of 25. The fact that the parole officer does include in there that my client was issued a violation of probation warrant, yet does not include it in the addendum, to me is simply an attempt to try to reviolate him at some point in the future. And I don't think that's appropriate. I think that there is enough information included within this violation that it should have been included here, and that disposition should also have been included as part of the addendum. And I'm just pointing that out and asking that to be taken into consideration, as that matter was sentenced and disposed of on the same day as his other cases that were in court and that are part of the violation. So with all of those comments made, I would be asking that my client be allowed to re-parole at his TS eligibility date being January 8th of 2025. He can self-sponsor to an address that's included within Defense Exhibit 1. His family does continue to pay for that apartment for him. He's eligible to return to his employment at John DeGrand and Sons as well. So again, that would be our request. Thank you.
Thank you. I'll be right with you with my recommendation. All right, so I've listened to testimony, have reviewed all the evidence submitted by the state. I will, as was previously stated, you were out there for about 2 years and 5 months. However, you do have a prior criminal violation, which you received a 9-month sanction for on this period of supervision. You did receive a new conviction as well on the second time returning. Based on this information, I'm going to recommend that parole be revoked to be re-paroled for April 8th, 2025, which is approximately 6-month period confinement as sanction. This is the US date on the new conviction. I recommend the following parole conditions. I'm going to put halfway house placement on there, just a backup. I am listing your self-sponsored residence as where you should go. Behavior management program for anger management, no consumption of alcoholic beverages, no contact with your co-defendants, Montoya Martin, Jerome Parkins, Juan Mendal, no contact with your victims, AS, AT, CK, and SR, and a general no contact with Jasmine Thompson. My findings are going to the parole board on December 19th. So the board's going to make the final decision. They can let you out as soon as that 1/8/25 date. They can agree with mine on that US date of your new conviction of 4/8/25, what I recommended, or they do have the ability to revoke all special parole. Anytime in between there, they can do that as well. Just so that you're aware of that. Do you have any questions?
No, ma'am.
Okay, so I wish you the best of luck, sir. I hope you're doing well. I hope that continues when you go back out.
Yes, ma'am.
All right, you're all set.
If you have any questions, Tyson, you can give me a call, okay?
Okay, thank you.
All right, good luck, sir.
And you'll get everything in writing a week after December 19th, or you can talk to your attorney that day as well.
Okay, thank you.
All right. Bye. Thank you.
Thank you. Have a good day.
You too.
Thank you.
Morning, Mr. Collette.
Good morning.
Morning. Your attorney's here, so we're going to get started with your revocation hearing.
It's not, and I was sitting on the room, but they're, out of traveling. Okay.
Yeah. Morning, I'm P.O. Meisinger, hearing examiner for the Board of Pardons and Paroles, revocation hearing concerning Collette Tylon, number 346240. Today is December 10th, 2024. This hearing is being conducted via video at the BOPP Central Office in Osborn Correctional Institution. This is a public hearing and public access. This hearing is available via video live stream. Please state your full name and DOC inmate number for the record.
Tylon Collette, 346240.
New counsel here today?
Sure, Attorney Alfonzo Sirica, Public Defender with the Parole Revocation Unit on behalf of Mr. Collette.
This is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of fact as to each of the charges against you. The state, not you, has responsibility to prove the allegations by a preponderance of evidence. That is, the better weighted evidence must establish that, more probable than not, the allegation is true. If I do not find that there is a preponderance of evidence to support a violation of one or more conditions of your parole, I'll reinstate your parole, which means releasing you and placing you back on parole supervision. If I find you have violated one or more conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I'll make a recommendation as to appropriate sanction, and my recommendation be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing would be provided to justify additional confinement. So this is the procedure. I'm going to read you your rights. Then we're going to review the parole violation charges, state your appeal is framed against you. I will review and identify exhibits filed for the record. Counsel will then have an opportunity to present a relevant testimony. After considering all the evidence presented, I will announce my findings. If I find that you have violated one or more conditions of your parole, counsel will have an opportunity to speak to your background history. Do you have any questions about the purpose or procedure?
No.
You have important rights today. You have to have an attorney. You have an attorney here today. You have right to receive the written notice charges of violation. Did you receive the written notice?
Yes.
You have a right to view the evidence against you. You have a right to submit evidence for your case. At this hearing, you have a right to call and examine voluntary witnesses and cross-examine adverse witnesses. Do you understand these rights and are you ready to move forward?
Yes.
All right, so now review the charge, state your appeal is framed against you, and the information underlying each charge. So charge 1, to obey all laws, drugs. You're charging officer reported on 1/12/2024, operating a motor vehicle and were in possession of 2 bags located inside the vehicle. The 2 bags were located in an area under your control inside the vehicle. You were the only person in the vehicle at the time of the traffic stop. 1 bag containing 67 grams of cocaine. Another bag also located inside the vehicle in an area under your control containing 68 grams of cocaine. Based on your actions, you're in violation of the special parole condition, obey all laws. I will obey all laws to the best of my ability for all my legal obligations, including payments of all applicable child support and minimum money orders. I will notify my PO within 40 hours of my arrest for any offense. I will not use or have my possession or control any illegal drug, narcotic, or drug paraphernalia, firearms, ammunition, or any other weapon. Charge 2, under bail laws, weapons, charging off support at 1/12/24. You were operating a motor vehicle and you were found by the police to be in possession of a backpack inside the vehicle at the time of the motor vehicle stop. A search of the backpack that was located in the vehicle in an area under your control revealed 3 loaded tan handgun magazines and 1 loaded black handgun magazine with varying amounts of ammunition, a tan Glock 19 handgun, and a black Glock 43 handgun located inside the backpack. Both firearms were confirmed to be stolen in Burlington, Vermont. On 1/15/2024, a search of the hotel room where you were residing in revealed a Glock speed loader, a barrel brush, and the end cap to a Glock magazine. Based on your actions, you're in violation of special parole condition, obey all laws. Obey all laws to the best of my ability, fulfill all my legal obligations, including payments of all applicable child support and money orders. I will notify my PO within 48 hours of my arrest and any offense. I will not use or have my control any illegal drug, narcotic, or drug paraphernalia, firearms, ammunition, or any other weapon. And the state has filed the following exhibits that are pre-marked for identification purposes as Exhibit A, signed statement of understanding and agreement conditions of parole. B, remanded custody order. C, violation notice of parole violation. D, parole violation report. And E is the arrest warrant ending in 05104. Did you receive notice of parole violation report, and those other documents I marked, and did you review them?
Yeah.
And counsel has filed the following exhibit pre-marked for identification purposes. Defense Exhibit 1, list of parole accomplishments and future plans for parole reinstatement. Do you need to continue sharing and obtaining additional evidence?
No.
We have no witnesses today, so now defense opportunity. If you'd like to.
I have Mr. Collette put on the
Sure.
record, please.
Mr. Collette, please raise your right hand so I can swear you under oath today so you can speak. You solemnly swear, sincerely affirm, as the case may be, the evidence you shall give in this case shall be the truth, the whole truth, and nothing but the truth, so help you God on penalty of perjury?
Yes.
All right, go ahead.
So regarding charge number 1 on the drugs and charge number 2, Mr. Collette, under weapons, you recall, we had a preliminary hearing on October 25th, 2024, correct?
Yes,
Okay, and you recall, we put on the record, you were supposed to be re-paroled from a previous sanction on October 10th of 2024, correct?
yes,
Were you ever released on October 10th of 2024?
no,
Okay, and you've been incarcerated since when, Mr. Collette?
June 10th.
Okay, June 10th. And there was a previous violation that you were remanded for in June, correct?
Yeah.
Okay, and these allegations of these two technical violations go back to January 12th of 2024, correct?
Yes,
Okay, and since you've been incarcerated since June, today is exactly, my math is correct. You've been remanded for 6 months, exactly, right? From June 10th to December 10th.
yes,
You've been sitting in the Connecticut jail, correct?
yes,
You've been served, have you been served any warrants from any out-of-state agencies?
no, sir.
You're currently being held on any types of bonds? Connecticut bonds, out-of-state bonds?
No,
Okay, I don't have anything else to add. These are the same comments that I put on the record and Mr. Collette put on the record at the preliminary hearing. I apologize for repeating myself. I don't have any additional evidence. The evidence is the same, but nothing's happened since October 25th. And once again, my client has been incarcerated since June 10th. He was never released on October 10th of 2024. No action has been taken regarding any criminal charges. He does not have any cases pending, does not have any bonds anywhere. I do want to be heard about his background at the appropriate time. Thank you.
Thank you. All right, so what I'm gonna do next is I'm gonna announce my findings. So regarding charge 1, I do find you violate condition on obey all laws drugs based on the evidence that was provided in support of that charge, exhibits A and E. And on charge 2, I do find you violate condition weapons based on the evidence provided, exhibits A and E. That includes the fact-finding portion of the hearing. Before I make a recommendation, counsel will have opportunity to speak to your background and history. This purpose part of the hearing is to help determine what outcome I will recommend. So if you would like to at this time.
Yes, on behalf of Mr. Collette, I am respectfully requesting he be reinstated as soon as possible. Once again, not to keep repeating myself, he's been incarcerated since June 10th of 2024. He was never released on October 10th. These incidents go back almost a year. January 12th of 2024 is the allegation series. 36 years old. He does have 3 children. On his previous release, he was sponsored by Ms. Meisinger in Putnam. He was there until he was remanded. As far as work, he did work previously full-time third shift loading and unloading trucks for Capstone Logistics in Delgado, Connecticut. He was there for about 5.5 months. Also worked with his family food truck, Street Eats, out of Danielson, Connecticut. He did indicate to us in 2021 he did successfully complete domestic violence programming. He also did an intake at Community Health Resources, CHR, for relapse prevention. He was put on the wait list for that. And then he also indicated to us, it looks like in 2021, he did complete some outpatient programming during COVID via Zoom. He's employed in the facility since September. He's as a hallway janitor at Osborn Correctional. He'd like to return to the same sponsor he was at previously. Ms. Meisinger provided you with an address and a phone number for her, and he does wish to study culinary arts due to his family business. Also was hired by Dual Temp Agency full-time.
No, I wasn't hired by Dual Temp.
You're not hired by them? I'm sorry.
No, I'm pursuing a job through Dual Temp.
With them, I apologize.
I mean, the job's basically in the bag, but I just gotta get out and get the job.
Correct, and you still have availability to work at your family's food truck, correct?
Most certainly, in April when it starts back up again.
Okay, so
That's
that's a little bit of background on Mr. Collette. Thank you.
So I'll be right with you with a recommendation. So I have reviewed all the evidence submitted by the state. I've listened to testimony. I will put on the record, I do note that you've been incarcerated 6/10/2024 for, that was your date that you were supposed to be, or you came in on last time for the last violation. You returned, or your remand was as of 10/10/24. So I do note that. You do have 2 prior parole violations, one for absconding and one is a technical violation. So this is your 3rd parole violation on this period of supervision. For our records, you have failed 3 out of 4 past releases into community supervision. And your officer recommended a 6-month recommendation for, is the recommendation 6-month incarceration. You are on parole till April of 2025. So based on the nature of the violation, as well as the additional information I just stated, I am going to recommend that parole be revoked and that you remain incarcerated until your special parole completion date of April 19th, 2025. This is about a 6-month sanction. Then you would be off of special parole. My findings are going to the parole board though on 12/19. So the board's going to decide. So they can let you out as soon as 12/19. Or any other time after, should they choose to. You'll be notified of that. You'll get it in writing about a week after what the board decides. Do you have any questions?
No.
So you're all set for today then, or you can talk to your attorney that day to find out what happens as well.
Tylon, give us a call. You can get a call in. Give me 1 second. Let me just take a look at. You can get a call into our office on Friday, December 20th. One of my secretaries can give you the information over the phone and what the final outcome is. Like she indicated before. Okay. Good luck to you.
Yep.
Good luck, sir. Good morning, Mr. Bennett.
Good morning.
Morning. We're here today for your revocation hearing. So we're going to get started with that. Good morning. I am P.O. Meisinger, hearing examiner for the Board of Pardons and Paroles. It's a revocation hearing concerning Bennett Jason, number 159113. Today is December 10th, 2024. This hearing is being conducted via video at the BOPP Central Office in Osborn Correctional Institution. This is a public hearing. Public access to this hearing is available via video live stream. Can you please state your full name and DOC inmate number for the record?
Jason Bennett, number is 159113.
You. This is revocation hearing to determine whether you have violated conditions of your release. I will review and make findings of fact as to each of the charges against you. The state, not you, has responsibility to prove the allegations by a preponderance of evidence. That is, the better read evidence must establish that more probably than not the allegation is true. If I do not find that there is preponderance of evidence to support a violation of one or more conditions of your parole, I'll reinstate your parole, which is place you back on parole supervision. If I find you have violated one or more conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I'll make a recommendation as to appropriate sanction, and my recommendation be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing would be provided to justify additional confinement. So this is the procedure for today. I'm going to read you your rights. Then we're going to review the parole violation charge, state your appeal is bringing against you. I will review and identify exhibits that are filed for the record. You will then have an opportunity to present relevant testimony. After considering all the evidence presented, I'll announce my findings. If I find that you have violated one or more conditions of your parole, you will have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure right now?
No, I do not.
Okay. Your important rights today, the right to have an attorney present. Do you want to continue without counsel?
Yes.
You have a right to receive the written notice of charges of the violation. Did you receive that written notice?
Yes, I have.
You have a right to view the evidence against you, right to submit evidence in support of your case. At the hearing, right to call and examine voluntary witnesses and cross-examine reverse witnesses. Do you understand these rights and are you ready to move forward?
Yes.
Okay, so we'll now review the charge, state your appeal is raised against you, and the information underlying each charge. So charge 1 under release direction GPS, your charging officer reported on 7/11/24, you're placed on GPS. You signed GPS agreement. You failed to charge your GPS. This violates your signed GPS agreement number 4. I am responsible to ensure the GPS tracking device remains charged by connecting the charging cable to the tracking device and plugging the charge cable into an electrical outlet for at least 2 hours a day. Charge 2 under release direction absconder. Your charging officer reported on 7/14/24. You're scheduled to return to Roger Sherman Halfway House from your employment at 11:30 p.m. When you did not show up, staff from the Halfway House contacted your employer as well as your cell phone and no one answered. Staff then called surrounding hospitals, police departments, and attempted to locate your whereabouts, but were unsuccessful. This PO tried locating you utilizing the GPS system, but you allowed your battery to die. This PO tried calling you on your cell phone. Someone answered your phone but stated they didn't know who you were. This PO reached out to one of your contacts and informed her that they have not heard from you, but that you most likely left the state as you had done the same thing in the past. As of the report, you have not been located and have not notified Parole whereabouts. Charge 3 under bail laws drugs. Your charging officer reported on or around 7/10/24, use cocaine. Charge 4, no consumption of alcoholic beverages. Charging officer reported on around 7/10/24, you consumed alcohol. Charge 5 under halfway house placement. This is in 2 parts. Part 1 states on 6/30/24. You were issued a shopping pass to Hamden Plaza with a return time at 8 p.m. You did not report back to the program nor contact the program. On 7/2/24, you contacted this PO and stated that you reported the Yale New Haven Hospital on 7/1/24 around 3 p.m. Your whereabouts community were known for 19 hours. Your actions violated the halfway house agreement and only locations indicated on an approved community pass unless changes have been authorized by staff and no such changes have been authorized. Part 2 states on 7/9/24, you failed to return back to the Roger Sherman Halfway House and work at 11:30 p.m. You did not report back to Halfway House until 7:30 a.m. on 7/10/24. Whereabouts the community were known for 8 hours. Your actions violated the Halfway House agreement. I will only go to locations indicated on an approved community pass unless changes have been authorized by staff and no such changes have been authorized. And the state has filed the following exhibits that are pre-marked for identification purposes. As PCS, A is PCS signed conditions, B, halfway house agreement, C, the connections incident report, D, connection incident report, E, offender misconduct, F, the connection infraction report, G, voluntary admission, H, offender misconduct, I, GPS agreement, J, connection incident report, K, offender misconduct, L, remand, M, notice of parole rights, and N is notice of parole violation. Did you receive notice of parole violation report, and those other documents I marked, and did you review those?
Yes, I have.
Okay. Do you need to continue this hearing to obtain any additional evidence?
No.
We have no witnesses today, so it is now your opportunity to respond to parole violation charges against you. However, remember that you may remain silent if you so choose. I am going to swear you under oath, because if you don't speak at this part, I'm going to have you speak later in regards to if you have future plans. So can you please raise your right hand for me? You solemnly swear, sincerely affirm, as the case may be, the evidence you shall give concerning this case should be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury.
Yes.
Okay, so would you like to say anything in regards to those charges that I just read?
No.
Okay.
No.
All right, so then what I'm going to do next is I'm going to announce my findings with respect to those charges based on the evidence that I have received. So regarding that charge 1, release direction GPS, I make a no finding due to there being insufficient evidence to support the charge. There's no evidence that you did not charge your GPS unit. On charge 2, I do find you violated condition absconder based on a warrant being issued by the BOPP and evidence that was provided, exhibits A and C. On charge 3, I do find you violated conditional bail laws drugs based on the evidence that was provided in support of the charge, which is exhibits A, D, and E through G. On charge 4, I find you violated condition no consumptive alcoholic beverages based on the evidence that was provided, exhibits A, D, and E through G. And on charge 5, I find you violated condition halfway house placement based on the evidence that was provided, which is exhibits A, B, J, K, part 1, and A, B, D, F, and H on part 2. So that includes the fact-finding portion of this hearing. Before I make a recommendation, you will have an opportunity to speak to your background and history. This purpose part of the hearing is to help determine what outcome I will recommend. So would you like to say anything in regards to future plans, going back out into the community?
Yes, my future plans are, actually to, seek help. At this point in my life, at my age, I come to the determination, my heart and my head, that I need to ask for help, especially with my mental health. A lot of it stems from there. I don't know if it was the stigmatism behind it in the past, but I need to deal with that. So I don't, revert to consuming alcohol or trying to medicate. And also that I need help and seek the help, that I have to put into work. Nobody's going to do it for me. I just want to have success when I get out, and also not working at restaurants at night as a chef anymore, which is a huge trigger for me. I need to admit that it's an unhealthy environment, and do something else, at least for a while, and just listen to my sponsor and do what I got to do for me. And just be a productive member of society where I'm a good father, a good son, a good brother, and a good friend.
Where do you plan on going back to? Or do you need housing or?
Yeah, I'm going to need housing. Also I need to get involved with therapy again. And just going over some things that have happened, with my PTSD, my depression, and I understand now that I have to, I have to ask for help. So that is my plan. Employment is usually not an issue for me. It's picking the right employment. I think I need to put my pride and my ego in my back pocket and understand that, I have to take care of me first, and what's healthy for me.
I appreciate your statements. So I'm going to put in the record. So you were out there probably after your last reinstatement, because you have a prior technical violation in 2023. You were out there about 3.5 months or 9 months before you absconded from supervision.
Yeah, 3.5 months. Yeah.
Yeah. This is, so as I said, this is your second violation. And it looks like you were found in Oregon. So you left the state as well.
Yeah.
It's unfortunate because there's right ways to do things if you want to go somewhere else. If you're doing what you're supposed to be doing, they work with you. And it's unfortunate that this keeps happening.
Very poor decisions on my part. Very, very poor.
And you're only on parole till April. So you don't have it much longer as well. I mean, based on what I have, I am going to recommend that parole be revoked, you remain incarcerated until your special parole completion date of 4/14/25. This is a 5.5 months sanction. So what I'm going to do, I'm going to present it to the parole board on December 19th. So the board's going to obviously review your case. They can let you out as soon as 12/19. If they want you back out in the community, they can do that. They can let you out anytime prior to that April date, or they can revoke your special parole. Do you have any questions about that? You understand? You're going to get it if you're still there after 12/19. I'd give it a week. You're going to get it in writing from the parole board. It's going to be the disposition. It's going to say if they did want to re-release you, what your conditions would be in your re-parole date. And then so you'll know what the final decision is from the parole board.
Okay. So pretty much the recommendation is EUS.
Yes.
Okay.
Yeah.
Okay. Understood.
That's the recommendation, and I do wish you the best of luck, and I hope you get this treatment you need so that you don't ever come back here. I wish you the best of luck with everything.
Okay. Thank you.
But all right, so you're all set for the day, sir. Good luck.
All right. You too. Have a good day.
You too.